Well, good morning and good afternoon, wherever you are watching this. I'm Jamie Danker. I'm the Director of Privacy at Easy Dynamics Corporation, and I'm here with my colleagues Annie Bai and Shannon Don to talk about one of my favorite subjects, privacy, and how authentication can be an enabler of better privacy. Just a little background about myself, former civil servant in the US federal government, 15 years, first at the US Government Accountability Office, and then about 10 years at the Department of Homeland Security, working on various issues, privacy-related issues throughout the department, including the E-Verify privacy officer, which obviously had a lot of identity nexus, as well as my last stint at Homeland Security, supporting and leading the privacy program at what is now the Cyber and Infrastructure Security Agency. And at Easy Dynamics, I lead the privacy practice here, and I've been supporting NIST on development of the NIST Privacy Framework, as well as other federal agencies as they implement identity solutions. So first, I want to pass it over to my colleague Shannon Don over at the Federal Deposit Insurance Corporation to introduce herself, give a little background on her experience with identity and authentication, and then over to Annie. So Shannon, on to you.
Thanks, Jamie. Good morning, afternoon, evening, everyone. So yeah, I'm Shannon Don. I'm the chief of the privacy section at FDIC. So in that capacity, I run the FDIC's enterprise-wide privacy program. I've been doing that for it's coming up on 4 years. And so we cover all of the privacy responsibilities, internal to the FDIC, from baking good privacy into our systems as they develop, through breach response if something goes wrong, and everything in between. And so in that capacity, we've dug into some really interesting privacy issues when it comes to authentication, from our interactions with the public online, from our some of our formal access and amendment processes as well. Prior to that, I was on temporary duty to the OMB Executive Office of the President, where I worked on a lot of the foundational government-wide privacy guidance for those of us who do privacy in the public sector. And prior to that, I spent about 10 years in Homeland Security doing privacy work in different offices and capacities, from headquarters to components, including the Citizenship and Immigration Services, where Jamie was a colleague, and we again had some very interesting authentication privacy intersections when it came to serving the public. So thanks, Jamie, for having me here.
Okay, so hi everybody, I'm Annie. I have been working in the private sector and the nonprofit sector for quite some time, doing privacy program management and compliance and legal guidance. Privacy, data security bleed into so many areas in all sectors. So it's been really always constantly changing, and I'm happy to think about what this type of audience would like to know and how we can really, move the world forward, as everything we've seen during the pandemic is so not only data centric, but internet centric. And I think it's really important to think globally as well when we talk about improving privacy regimes, and so much can be done by those of us who work in these fields. And I think that we should lead as well as just following emerging laws and regulations.
Yeah,
I'm just going to set us up by talking about what data subject rights are, which is data subject rights are basically what I think of as like the latest bandwagon in privacy laws. And this is something that I'm going to present to you, the existing state of what's happening. But I also want you to think that this doesn't have to be the way, right? So data subject rights are something that have been very popularized by the European regimes, and all sorts of countries around the world are now jumping on this GDPR bandwagon. The GDPR is the General Data Protection Regulation for the entire EU, as well as actually claiming extraterritorial scope. So even businesses or establishments that are not European, if they process personal data of Europeans in a certain way, not like incidentally, but if you're actually targeting Europeans with products and services, or if you're monitoring and profiling them, the European law regulation does claim jurisdiction. We've seen it followed up with a similar law in California called the CCPA, the California Consumer Privacy Act. We also see this in Brazil with a very GDPR-like law. The Lei General de Dados Protection, and there goes my Portuguese. So, and what we're talking about today and why we're bringing this to the authentication community is that I feel that we have jumped to a place where we're trying to empower individuals and consumers to have these things called data subject rights. But in that, it's a very powerful right that's been granted to people. But there are protections and safeguards that need to accompany them that shouldn't necessarily be in the hands of individuals. So the rights that we have been given across these different jurisdictions and to differing extents when it comes to Europe, California, et cetera, are things like called the right of data portability, where you have the right to ask businesses to provide you the information they hold on you in a format that's usable so that you can transfer your services from one similar entity to another. So that you're not locked in. The right of erasure, or the right of deletion, or the right to be forgotten. Very like poetic sounding phrases, a lot of people have latched onto them, have to do with your right to request that your personal data be erased. There's the right of rectification, which is to have your personal information corrected. There's the right to restrict processing or to object to processing, or to object to automated decision-making, which is just, like what we call an opt-out. Say, I don't want that within constraints. So a lot of this has to do with third-party marketing. There are also there's the right to access, which is just to see, just like I want to just see, I just want to know what you have on me. I may or may not want a request for it to be deleted. And the principles on which these rights are based have a lot to do with transparency of what's happening in a very complex environment. The data flows around the world and between institutions and commercial entities and non-commercial entities are very complex and hard for people to understand. So it's like, hey, here's the opportunity for you to find out what entities are holding on you. And that is supposed to trigger the principle of accountability. Now that all these orgs know that they are accountable or have to provide records or deletion processes, rectification processes, right? They're more accountable to consumers. However, all this is between the organizations holding data, personal data, and the consumers. There's a heavy burden on consumers. And this, like everything else nowadays, digital, can be gamed and it can be undermined. So we've seen in Europe, and we're seeing here now in the States, that by creating these rights, it's also creating an opportunity, like a threat vector to data. And we're even seeing automated, like mass requests for access and deletion. There are entities that are legitimate trying to help consumers, but this is also the same pathway that a malfeasant could take for nefarious reasons, saying, hey, I want to access all this information, I want to get copies of it, and that's just like the new data breach, right? It's like the front door instead of the back door. So this is where authentication, very thoughtful authentication, matters. And we saw in the CCPA that there is an attempt to say that, companies that are receiving these requests can and should ask to verify the identity of the data subjects. Make sure you're only providing this right, the data, the files, the access, the rights to the person who is entitled to them, to the actual data subject themselves, and not an imposter. However, that's not easy because there's not a lot of guidance or technically how to carry it out. So this is where those of us who have a lot more expertise in verification, authentication, and digital identity can really support and help. There are things like a reasonableness standard, which is very lawyerly. And what does that mean? You don't want to make it overly burdensome. Lawmakers did not want to give businesses or organizations an out by allowing a very onerous individual identification, right? If you ask for very onerous, like proof of who you are, that actually could be a blocker to people exercising their rights. So it's the whole balance of trying to still protect them, not just give everything out freely, but also not be burdensome. So there's a lot of back and forth. So it's kind of a fun seesaw that we're seeing play out. We've seen a lot of companies take very old school approaches, like mail me a copy of your passport, which is really not great, to be sharing around images, and also not accounting for forgeries and not accounting for the authenticity of the documents. We've seen like, send me a copy of your utility bill. We've seen like, you have to come into a branch, you have to come into an office to verify yourself. There's a wide range. So the implications for authentication is that there's room for leadership, there's room for innovation. And I'd like to, at this point, pass it on to my co-panelists.
Okay, Shannon, could you enlighten us a little bit more about the privacy risks implementing individual access? Obviously, Annie spoke to some of them, which I'm sure you may have some similar experiences in your federal government. But if you could even broaden it to the risks that are outside those cybersecurity related privacy events like data breaches.
Absolutely. Yeah, thanks, Jamie. And so Annie teed it up very nicely. And one of the interesting things about these privacy laws, there's GDPR, there's the CCPA, is that there's a set of fair information practice principles that underlie and can be gleaned through each of these. And so in the federal space, the Privacy Act of 1974 is one of the primary laws that we're making sure we comply with, and that's where individuals derive similar rights of access amendment. They don't have the right to ask for deletion, but they do have. There are requirements of agencies, FDIC, DHS, the agencies I've supported in this capacity, to make sure no systems are secretly kept. So publish what the system is, publish what the retention schedule is, and then abide by it. And because those principles of access, amendment, redress underlie all of these laws, they're similar, not exactly the same. And so a lot of the same risks are present in the federal space as the private sector space. But in the federal space or any public sector space, there's an additional responsibility, in my view, of governments, because in the private sector space, consumers have some degree of choice, not full choice, in every space. But when it comes to a citizen in their government, there's not choice. They can't take their business elsewhere, and so there becomes an additional responsibility of governments for when you've got individuals. So thinking back to specifically the context where I was supporting the U.S. Citizenship and Immigration Services, which is the component of DHS that served took somebody from the non-immigrant through immigrant status to maybe naturalize the U.S. These are people whose livelihood, their life, sometimes their family relationships, and their ability to be with their families might depend on having good data. Being able to check their statuses, they need that maybe online government service. And so equal to the responsibility we have to not accidentally disclose their data to an imposter is this responsibility we have to make sure that these people who maybe can't easily pull up a utility bill because addresses are a bit less stable, who maybe can't do our out of wallet quiz, it's got its other issues, but if you haven't had a mortgage in the U.S. for 30 years, you can't be serviced by those third parties providers. And these are people who have additional hurdles to getting their information, and also their access to the information is so important. And I mentioned all of these rights are derived from this Privacy Act of 1974. Note the year. It really predated a lot of the identity fraud concepts that we're now. So we're having to take those principles and concepts that were great. They're really forward-leaning concepts back in the 70s, and now we're applying them in today's world. We've got governments using the Salesforce Communities portal and to do some self-service. But we've got kind of statutory requirements where you must give a person access, you must give a person the right to amend their records, and work the balance between making sure that there's not, you're not giving data to an imposter, against the fact that different people from different circumstances are only able to avail themselves of so many options when we're relying on things like public consumer data. Jamie, I'll hand it off to you to talk about the Cases Act.
How about the Cases Act? Sure. And just to kind of springboard off of both what Annie and Shannon said, talking about privacy principles, in a lot of these privacy laws, it's the individual participation principle that's really underlying these rights. The idea that individuals should have the ability to access and amend their records or participate if a decision is going to be made about you. In the consumer space, however, what I've heard about the California law is that it was initially intended to sort of function as that Freedom of Information Act for consumers, which is quite interesting. And while the Privacy Act, you have those similar sort of Freedom of Information Act, I want to know what the government's holding on me, but there are also, the access and amendment rights that for certain records, obviously not for law enforcement records, they're not going to necessarily disclose those to an individual that's subject of an investigation. But there are additional rights through the Privacy Act, which definitely makes sense given it's, as Shannon, you're pointing out, that the government's holding the records. So for individual access requests, most agencies do have Privacy Act regulations that specify the level of identity assurance that they're going to provide within that. Some interesting issues. I stumbled across this called the Cases Act. It was called the Creating Advanced Streamlined Electronic Services for Constituents Act. So this is an interesting issue that sort of pops up when you're a citizen. Sometimes if you have problems, if you're a US citizen, for example, let's say you're a veteran and you're not getting the responses you want from the Veterans Administration. So you go to your congressperson and you ask them to help to look into your case, to act to speak on your behalf. And so in order to do that, most congressional offices will require under the Privacy Act that you signed a waiver that allows them to act on your behalf. Well, every single agency probably has a different form. Every congressional office has a different form. And so there was a recognition here that, the Office of Management and Budget should develop a standard form that all these offices can use and that it should be electronic. So, that's a big shift. We're still really in paper processes when it comes to authentication. And I think the government really would like to and is need to move to more of an online way. So this is just sort of one niche little example, again, of where in the law it shows up that it's about privacy in some respects because it's enabling the individual to access their rights, but recognizing that you need some modicum of verification before you do that. And then Shannon, I'll just kick it back to you to talk more broadly about government to citizen services.
Sure. Yeah, so this is a little bit of what I touched upon earlier, but so at the FDIC, we interact with the public directly when we're collecting, consumers may complain about their institutions. At previous government places I've supported, so I talked about the citizens needing to access their case files at USCIS in the immigration capacity, and in several capacities across DHS, there may be, direct consumer interactions. And just making sure that it can be very, it can be more intuitive to think through the risk for not giving data to an individual because you might breach their data. It can be nuanced as well because it can mean separating out the concept between if you have an authenticated identity and but not identity proofed, then maybe you can serve back to that authenticated identity any personally identifiable information that identity served to you without verifying that person is who they say they are, because you're basically not disclosing anything new. But if you're going to wrap back into your backlogs of 20-year case files and put it all together as one identity, then you need to identity proof before you serve up additional information. So for example, if I say, hey, I'm Shannon Don, I'm going to complain about my bank and, let me tell you everything. Let me tell me my bank account number and I'll create an account. It's okay for me to log back into that account and see. But if on the back end, that government servicer is going to say, oh, Shannon's been complaining for 10 years and we've answered your question, Shannon, before serving that answer up, that it's incumbent on that government agency or naturally any entity to make sure that I am who I say I am. And sometimes in the course of designing this business process, that can be lost. And so that's a blind spot I've seen. But solving for that, the next concept is really understanding the balance reached. And this is kind of echoing what Annie said between if access to data and transparency into how the data is collected and ability to correct your data or have some consumer rights over that data, that's a privacy right. Certainly having your data kept secure is another privacy right. These become in tension with one another, because if you keep it very, very secure, then I cannot access it. If it's so secure that it's inaccessible, I cannot access it and I've lost my right to amend it and have control over my data. If you make it too open, naturally, then others can access it, amend it as well, and you've not secured it. And so finding that balance is a function of what type of benefit it is, what the consequences, what the privacy harm might be to an individual for not being able to access versus for having it breached. So maybe maybe it's just a case status, and that case status is not data that could really be exploited, and so the risk to breaching the data is actually quite low. Versus if I'm truly Shannon Don, but I don't have the utility bills and so forth, and I can't do an out of wallet quiz, I don't have good public data on myself, but I can't access my case status, then I've got the data you kept on me is results in a privacy harm. You tip it a little bit more towards opening up those authentication versus the other way around. And so recognizing that making sure the authentication is and identity proofing are secure is a balance, because you're tipping it away from sometimes the ability to access and those other privacy rights. Okay. So back to you, Jamie.
All right. So we've heard a lot about both public and private sector laws and individual access rights. And I think makes it, what I'm hearing, Annie, what I heard from you is a lot, there's not a lot of guidance out there on how to do this. And I want to be slightly contrarian, maybe like just a tinge, that there actually is, I think, quite a bit of guidance. It's not going to tell you the exact answer of what the right mix of, identity proofing and authentication is, but there is guidance from the National Institute of Standards and Technology that can help programs think through some of these tough decisions, especially when implementing data subject access rights. And I can think of at least 3 on the top of my head. The NIST Privacy Framework that was released in January of 2020, the NIST Digital Identity Guidelines, Special Publication 863-3, and also the NIST Privacy Risk Assessment Methodology that was, started off as an interagency report called 8062, an Introduction to Privacy Engineering in Federal Systems. So just want to talk about a few examples of how some of this guidance can help think through these complex issues. So tiny bit of background on the NIST Privacy Framework. This was released in January of 2020. It follows the same format and structure as the NIST Cybersecurity Framework. So I'm sure many in the audience here are familiar with the Cybersecurity Framework. The Privacy Framework has 5 functions. Identify, and they use the -P to distinguish it from the Cybersecurity Framework because there are some overlapping functions and categories and subcategories with the Cybersecurity Framework, because as we know, privacy and cybersecurity do have overlap. So you have identify, govern, control, communicate, and protect. And underneath that, you have categories and subcategories. So basically increasing levels of granularity that discuss outcome-based that your privacy program may want to implement in its products and services. So it's a flexible tool that you can use to sort of frame your system's privacy capabilities and use for a communication tool. So when I think about, both what Annie and Shannon are talking about in terms of, like, let's say you're developing a product or service and you are subject to any one of these laws that require individual access. So you can go through the privacy framework and choose those categories and subcategories that speak to that. So I've only got a sample profile here. So there are many other categories that might be important for your organization's privacy program. But you might go to, for example, the identify function has a risk assessment category. And I think really any product, service, or system where you want to start off, whether it's for security or privacy, you want to start off doing your risk assessment. So you'd select that category. Now that doesn't really, answer the mail. You would couple that with NIST's privacy risk assessment methodology to really map out all of the system, product, and services processes all the way down to the very data action level, allowing you to see where risks might occur. And then you can help inform your decision-making on, what's the right level of authentication for, I'm a commercial entity and I want to let Shannon access her records, versus I'm a government entity and this is a sensitive system and I've got to really make sure Shannon is who she says she is. And you can also couple that not only with the risk assessment methodology, but with the digital identity guidelines as well, what I would consider an informative reference to help you do that that digital identity risk assessment. So other categories you might select for data subject access requests would obviously include and protect the identity and access management. In essentially this case, the product really is the identity service for implementing data subject access rights. And then, even thinking more broadly, if you are advising a program that's building a product or service that's creating records or data that can be linked to individuals, you also have to think about the capabilities for your organization to actually permit such access. And so I think the privacy framework there can help you think through that as well, especially in the control function. Some of the categories I don't have listed here include, allowing data to be accessed, allowing data to be deleted, which may or may not be a capability that you need to implement. So in Annie's context, she talked about the right for deletion. In Shannon's context for the Privacy Act, federal records, generally you don't really have the right to erasure there. That's one thing. The government, is will be the authoritative source on it. There might be correction rights, but the right to be forgotten does not exist for federal government records. So those are some of the other capabilities. And then the data processing management category, there are many treats in there that I think will help your program think through what you need to think about as you implement data subject access rights, including this dissociated processing category. So one thing I think organizations need to be leery of, whether it's public or private, is you don't want to require people to prove their identity at a level that is not commensurate with the risk. So the verifiable consumer requests are, I understand that for California Consumer Protection Act, to opt out of a list, you might have to verify your identity. Organizations should not be making that burden so high to prove your identity to exercise that type of right, for example. But there are also privacy preserving ways to do identity. And for example, your organization might want to select this attribute references are substituted for attribute values. I'm sure everyone in this audience is aware that we're at the stage now where we don't need to give full values of data elements. We can do a yes or no response. And that's something that's reinforced in NIST guidance in 800-623, where attribute references are substituted for attribute values. So trying to put it all together, there's a lot of different NIST guidance here, but you can start off, I'm going to just speak generically to experience working with a client where we started off looking at helping build a capability and attribute validation service, and what would a privacy framework profile look like for that. And these are just some of the sample categories and subcategories that might be selected. And some of the kind of revelations we had from that were, we developed this profile and, we selected these subcategories, and the CTD-MP8, the audit logs and records, are determined and implemented in accordance with the principle of data minimization. Really, when we selected that led to conversations with the product engineering teams about, what should this attribute validation service store? And so that helped develop an actual requirement that said, we're not going to capture PII, we're only going to capture what is necessary to reconstruct the transaction and to perform billing and such like that. So that was one kind of key example of where using the framework to help communicate across the organization, not just to other privacy people, but to the people who are actually building the software or the product or service, because it's great to talk about all these rights, but if your systems don't have the capabilities built in, your customers aren't going to be able to exercise those rights. And also, helps you implement other requirements. It could be, the framework itself is agnostic to laws like the Privacy Act and CCPA and GDPR, but it does include many of those key features that these laws, like the individual access requests, have. And so I would recommend taking a look at that, because your organization will be better positioned to implement some of these rights required by laws if you look at it more holistically. So with that,
Hey, Jamie, I just want to say before we wrap it up, I
Sure.
didn't consider it contrary at all. And I think that, really like the flow of looking at the laws. And my point was that the laws are not specific enough, right? The GDPR, the CCPA, be reasonable and whatnot. And I'm so glad that we've seen that from the public sector and all the frameworks you mentioned, that there is guidance that we can look to that's objective and it's expert, right? The thing is, when you have a law and within the body of the law itself, or in like regulatory supervisory guidance, they're not mandating, let's say, looking at NIST or using.
Oh, okay, fair, yeah.
Right. So this is why this audience and this community that we're in here can really make a difference. I also have a question for both or either of you, that I also feel that like just creating these new rights, and there's so much hoopla and excitement around them, and there are a lot of consequences, the fines, et cetera, and the enforcement. But I feel like we shouldn't create a whole new thing. There are so many important efforts around digital identity, right? A portable, extensible digital identity. I think that centralizing it as opposed to trying to manage, and the reason it's so difficult for individuals to manage their electronic personal data is that everybody's got different authenticators and different accounts, and across all the different sectors, and within one sector, different businesses. And I'm just wary that something that is supposed to be empowering consumers is actually creating more bureaucracy for them. And I think that goes to your point, like, hey, let's look at what's existing, let's look what's out there. But I think that we should think more about centralizing efforts and frameworks, and even regulatory burdens.
So I can respond to that, Annie. I think that I think you make excellent points. It becomes again this concept of balance. Consumer ease helps them exercise those rights more reasonably. You don't need to be an expert in this to be able to exercise your rights under these laws. A centralized identity can carry with it privacy risks as well, which are not insurmountable. It's just being thoughtful about them. In the public sector, particularly U.S. public sector, it becomes more tricky. It becomes more nuanced, different. It becomes almost something that is cultural. There are a lot of nations, not U.S., that have very a national identity. National identifier, and then that helps with very seamless government services. We've talked before about like Estonia, just different culture than the U.S. And so, we mentioned the Privacy Act. The Privacy Act has one of its broadest applications is it is very prescriptive around when social security numbers may not be used, for example. And so because of the history of the how social security number was evolved and had inadvertently became a proxy identification number, a lot of our concepts of a centralized identity in the public sector carry with it that weight. And so, again, it's just thoughtful implementation and making sure it's something that won't be a repeat of some of those privacy risks that we didn't account for in our earlier implementations of government identity.
Right. And I think I'd agree I guess I agree with both of components of what you're both saying. It would certainly be a lot easier if we had a centralized identifier. I hear that from the engineers at my company all the time. It would be a lot easier, but the policy implications are real. And having been at Homeland Security, you see that when data is created or collected for one purpose, and then somebody else wants to come and use it for another purpose, you can get into some real sticky issues. E-Verify, for example, the statute is very clear that it can only be used for employment authorization purposes and nothing more. And so, if you had someone coming in and asking for an extract of that database, it's not going to be compatible for the purpose that it was collected. And Congress was very intentional about that. So there are, I get the desire and I want it to be easier, just like anybody else. But I think we have to be really thoughtful about, are there legislative barriers we need to remove? But let's also be careful about how, that these identifiers can be used and thinking forward, talking, kind of going off what Shannon said, how Social Security, the use of the Social Security number, they never thought of that when they were established. So they're not easy solutions for sure. But I definitely want it to be more convenient, just like everybody else. And especially we're doing so many more things online now. We want to be able to do them conveniently, safely, and securely, and without compromising our privacy. So I just left here a page of resources for everybody to go check out. Many links to the digital identity guidelines, the Office of Management and Budget updated identity memo, and a couple of blogs that I wrote in the past year that really summarize some of these key frameworks, hopefully in a digestible format. And with that, we will be online on November 17th to answer your questions. So we look forward to seeing you all then.